Good morning, welcome to EduSat Network. Friend, as you know, today we are going to discuss an important topic, RTI Act, Right to Information Act. You know, this act has given a kind of weapon to the people or the officials also, and a landmark step in the good governance and transparency. So I think if we know much about this act, then we will be using in a better way. So we have organized a discussion on this very topic, and for discussion on this topic we have in studio Dr. Rajveer Singh Dhaka. He is associate professor in Haryana Institute of Public Administration, and his area of specialization is RTI and good governance. So on your behalf, I welcome him for a research lecture on this topic. Welcome.
Thank you. Thank you. Right to Information Act, as you know, was enacted way back in 2005. The complete act came into operation on 12th of October 2005 and since then all the citizens of this country are using RTI Act in seeking information from government and other agencies. And in the last more than, you can say, 8 years of this RTI Act, people are seeking so many information. That's why government and other bureaucrats are on their toes, and so many scams have been exposed. India got independence in 47, and Britishers enacted an act, Official Secret Act, in 1923. Everybody protested that this act shouldn't be there, but we continued with that act for more than 8 decades. Ultimately, our government enacted this new act, RTI Act 2005. This act has made that Gandhiji's dream virtually come true, where Gandhiji said that real Swaraj will come not by acquisition of authority by a few, but by the acquisition of capacity by all to resist authority when abused. All these years since independence, for more than 6 decades, system and bureaucrats in particular have been considering that if we are providing services, that's our prerogative, and they were sometimes have been indifferent to the needs of the people. But this act has given a weapon in the hand of the citizenry of this country, where it has given power to the citizens and public in common to ensure that officers or the system having authority should be on the toes, and the real power has been given to the citizens in true sense. Though in our Constitution and Fundamental Right 19(1)(a), it's there that Indian citizens are enjoying freedom of speech and expression. And anybody all these years, if has been approaching different courts, High and Supreme Court in particular, they have been getting information, because courts have been telling that yes, if Indian citizens are given freedom of expression and speech, it means, as per these different judgments of Supreme Court, Bennett Coleman versus Union of India, State of UP versus Rajaraman, SP Gupta versus Union of India, Secretary, Ministry of Information and Broadcasting, Government of India versus Cricket Association Bengal, 95. All these judgments, Supreme Court has been of the view that if the Indian citizens are enjoying freedom of speech and expression under 19(1)(a), it means automatically our constitutional fathers have given that presumed or inferred fundamental right to the citizens of this country. If somebody is enjoying that freedom of speech and expression, automatically they are also enjoying that right to know. And this ultimately in 2004, People Union for Civil Liberties versus Union of India 2004, Supreme Court pronounced the judgment that if you are not disclosing information to the citizens, then it means you are violating their human rights. Under all these circumstances, our government enacted this act, and now the citizens of this country are enjoying information under RTI Act. But the ultimate goal of just this RTI Act is not just seeking information, instead using these information for ensuring good governance. In the last 2 decades, especially after that LPG regime, the main objective, of course, of all these reformist agendas is that good governance has to be introduced. RTI is one of the key instruments as far as good governance is concerned. There are some of, you can say, few silent features of RTI Act. First and foremost, I would like to make it clear that under RTI Act, citizens of this country are having right to have that access to information only to those information which are not in public domain. If some information is already in public domain, that you need not seek through RTI. You directly have access to that from that source. And if some information is held by some public authority, that information has to be disclosed under RTI. At the same time, there are some instances that some public authorities are overloaded with RTI applications. As per the preamble of this act, a balance has to be maintained in disclosing such information. Means what? We have to keep in mind the availability of the resources and the information and their public interest also. Let me go through some of the silent features of this act. The first one, of course, is maximum disclosure. The second, duty to publish. We are to disclose as many information as we can, and at the same time all the public authorities are supposed to, are duty bound, are obliged to disclose information suo motu. Suo motu means what? For those information, citizens of this country shouldn't approach these public authorities with RTI applications. Instead, these information should be disclosed by public authorities themselves. There are 16, 17 such information. For example, what are the powers and duties of different officers in that public authority, where from public authority is getting funds, and how these funds are being utilized, what is the hierarchy of officers in public authority, how the total funds are utilized, salary structure of the employees, how the decisions are taken. These are very common information which should be disclosed suo motu. Not only this, public authorities are supposed to put their record or house in order. If somebody is coming to some public authority, then many times public authority is of the view that, oh, we don't have this record in proper shape. Public authorities are bound to disclose their information in more effective manner, more managed manner, just like library, you can see information should be managed in a catalogued and index form. And to a large extent, these information should be disclosed on website. Then comes how one could approach public authorities and who is there to provide this information. As per the mandate of this act, there are 3 main functionaries in every public authority. One is first appellate authority, second public information officer, and third assistant public information officer. The main of these 3, the person concerned with disclosing information is public information officer, PIO, and if there is any contravention of the act, if that PIO is unable to provide information, penalty is imposed upon that PIO. And very strange, this is the only country where there is penal provision in RTI. There at present RTI in one form or the other there is in about 100 countries. But our country has only that penal provision. From there we could make out the mentality and mindset of the people who are there in such a, that if there is you can say some push or there is you can say penal provision, then they could work more effectively. That's why this clause has been put there. And at the same time, there is one assistant public information officer. As per section 5.2, his duties are given in section 5.2. APIO is not supposed to provide information. Instead, APIO is there just to receive application and forward it to PIO, just to receive appeals and forward it to the first appellate authority or the information commission, as the case may be. Otherwise, the providing information is the duty of only PIO, public information officer. But then why somebody would be keen to become PIO in the public authority if there is a, you can say, staff of 200 or 1000 or even 1 lakh officers sometime? Everybody would avoid responsibility, and there is no extra remuneration or some kind of other, you can say, packages for these designated PIOs. Keeping that in mind, our people who enacted this act were very nice to introduce one more section, that designated PIO could seek the assistance of any officer in the public authority while providing information. It means what? If somebody is coming with the RTI application, then designated PIO can seek the help of any officer in that public authority. That officer means that officer should be concerned person. He should be either the custodian of the record, or that officer should have generated that information. This way he could seek, or she could seek, the help from all these officers in the public authority. And if, as per the next subsection, section 5.5, if the person who has assisted the designated PIO is unable to help him properly, or during such help there is some contravention of the act, the person who has assisted the designated PIO would be considered as PIO and would be penalized. It means everybody in the public authority is PIO. 1 or 2 are designated, other are deemed PIOs. Everybody can be penalized under RTI Act. If somebody is taking RTI applications casually and getting, you can say, creating some problem, or you can not playing his role effectively, in that case, if there is contravention of the act, of course penalty could be imposed upon everybody, from clerk to the head of the public authority. Then how we could then apply for information? So many people are staying still in the villages. Literacy rate is almost, you can say, 60-65%. Then what to do? People can directly apply on plain paper, or they could address that application to API or PIO in English or Hindi or the official language of the region. And if somebody is illiterate, some applicant is illiterate, in that case, designated PIO is bound to help that illiterate applicant in writing that application. Either he or she would write, or they would help that applicant in getting that typed or writing itself. Then there is one more important clause is there that if I am unaware where this information could be, or which public authority is having the custody of this information, if by mistake I address my application to a public authority, which that public authority may not be the custodian of that information, in that case, the public authority which received this application or request is duty bound under section 6.3 to transfer that application to the another public authority or the concerned another public authority, and at the same time inform the applicant that yes, this application addressed to us was not concerning us, instead this information requested relates to another public authority. We have transferred this application to that public authority, and at the same time informing that applicant, and of course in that case the second public authority would directly deal with the application. Then what is the time limit as such? Under RTI, under RTI, normally information are provided just in 30 days. Just in 30 days. If there is some information relating to life or liberty, that information has to be supplied just in 48 hours. Though there is no clarification which information is concerning life or liberty, and but we can make out from so many judgments of Supreme Court and different courts as well as different time interpretation. If somebody is seeking life or liberty information, that applicant should justify how it could be treated as life or liberty information. Normally, information are to be provided in 30 days, but that is highest limit. If some information is readily available, then PI shouldn't take more than you can say 5-10 days also. Sometimes information could be disclosed just in a week also, but 30 days is, you can say, maximum limit for disclosing such information. Many times PIOs are also at the receiving end. PIO, if somebody is unable to compile information even in 30 days time, then he or she should convey the applicant that if of the information requested, I am supplying you the 5, 10 or 50% or 70, then under section 7.2, they should remain in touch with the applicant. Otherwise, that would be considered as violation of the Act. It's better that designated PIO should always remain in constant touch with the applicant. Otherwise, that would be considered deemed refusal and penalty has to be imposed in that case. Many times people are of the view that, oh, information are not to be created, information are, though there is no provision in the Act. Instead, RTI Act section 2J relating to our right to information and the preamble of the Act itself says that information are to be provided which are held and controlled by public authority. Creation means a PIO is not supposed to give his or her opinion. Sometimes people are coming, why you have done his work or her work and why not mine? This is called creation of information. I am not supposed to justify or I am not supposed to disclose my view, what is there in my mind. Under RTI, if something is on file, one can get the Xerox of that file or noting anything. But under RTI, we are not supposed to generate information. Generation automatically means then that we are not supposed to give our opinion. Otherwise, let me quote section 7.9, which is very important section in this Act. This section 7.9 says, information are ordinarily provided in the form in which it is available. Form in which it is short. Information are ordinarily provided in the form in which it is short. Means कि भाई जिस तरीके से एप्लीकेंट ने मांगी है, in the same way PIO is bound to disclose it. Then many people think that, oh, it is creation of information. No. If something is already in your custody, I am asking in particular format, PIO is bound to give that information in that particular format. Creation should have been that was not in our record and we were giving virtually our opinion. Under RTI Act 7.9, information has to be provided in the form in which it is requested or sought by the applicant. However, there is one rider that if there is disproportionate diversion of public authority resources or it is detrimental to the safety of records, then in that case PIO may take, you can say, some relief and not disclose that information in that particular form in which it was requested. At the same time, there are certain exemptions. There are certain exemptions that which information are not, you can say, needs not to be disclosed. Information which would prejudicially affect the sovereignty, integrity, security, scientific, economic interest and relation with other countries. These information needs not to be disclosed. And at the same time, that would lead to the incitement of an offense. If we are having some password, some other, you can say, code word, that needs not to be disclosed. Otherwise, there could be, you can say, some may be incited for committing some crime. And at the same time, if some court or tribunal has prohibited against disclosure of some information, those information are also not to be disclosed. Otherwise, it would be, you can say, contempt of court. Many times, this issue again gets confused. Many people are of the view, oh, the matter is sub judice, matter is in the court, that's why we are not supposed to disclose it under RTI. No way. If you won't disclose information, if the matter is there in court, you can say, then it is virtually violation of that our natural right. You know? that audi alterum partem, you can say, principle is violated. If the matter is in courts, even Supreme Court, High Court and all bodies are falling in the ambit of this act. All these, you can say, public authorities are also having their first appellate authorities and public authority, PIUs. Then comes information relating to privilege of parliament or state assemblies are also not to be disclosed. Then there is one important, that information including commercial confidence, trade secret, intellectual property, the disclosure of which would harm the competitive position of third party won't be disclosed. However, there is again a rider that competent authority may disclose information if there is larger public interest. But under this act, the competent authority in central government is President of India, and secretaries or the ministers could be enjoying those delegated powers. Then the officers who are enjoying these powers may disclose this information if there is larger public interest. For example, if there is some construction, you can say, contract is given to some company, and some pillar, you can say, breaks down in between, or there could be some mishappening also, then these, you can say, these commercial trade secrets can be left apart, and of course this public interest prevails. In such cases, competent authority may disclose information. And at the same time, information available in fiduciary relationships are not to be disclosed. Fiduciary relationships mean patient and doctor relation, client and that lawyer, you can say, relationship. These information are not to be disclosed by the public authorities. Even all public departments are having their own legal experts. These legal experts are pleading these cases of these public authorities in the courts. Then in that case, they are not supposed to disclose because of fiduciary clause. Though there is also, you can say, that a rider that competent authority may disclose if there is larger public interest to that also. Of course, information received in foreign government are not to be disclosed under RTI Act also. And at the same time, safety clause has to be taken care of. Source of information is not to be disclosed. If some agency has raided certain premises, or even some intelligence security agencies are getting certain feedback that information is collected, that way source of information is not to be disclosed. At the same time, if the disclosure of information impedes the process of investigation or inquiry, in that case information is not to be disclosed. Let me, you can say, quickly go through these few points, then we would discuss, I can say, this 2 or 3 important aspects. Then personal information are not to be provided. After RTI Act, in these last 8 years, people are seeking so many information about each other, not only about, you can see, the working of the governance or the government funds in particular, but even seeking information of the colleagues or friends, or you can say, in that case, then this question of personal information also arises. Even the citizens in common are asking so many information relating to such cases. Then personal information are not to be provided. What does personal information means? Personal information means if the information disclosure has no relationship to any public activity or public interest, that is personal information. Or disclosure, if it would invade the privacy of some individual, then it is considered as personal information. But the question then arises, how to treat these applications, that this information is personal, this is, you can say, public interest. There is, you can say, the PIU has to apply his or her own mind more, you can say, systematically and judiciously. And if the information is falling in such categories, information are not to be provided. And there is also a clause that if information is relating to some individual, there is also a clause, third party clause. In that case, a notice has to be served to the third party that if it is not properly screened that it is pure public information, and if it is considered somewhat confidential by third party, in that case a notice has to be served to the third party. And in that view, that case, views of the third party are also taken, and ultimately on the basis of whether protected interest is large or the public interest is large, then this decision is taken by PIO regarding disclosure or non-disclosure. And there are, the beauty of this act is that there is provision of this commissions, judicial commissions, non-judicial independent commissions in our country in this act, where commissions are enjoying those rights, you can say, and obligations to penalize, you can say, those defaulters, PIOs. If somebody is violating some provision of the act, a commissioner can impose a penalty of rupees 250 per day, and this penalty amount can go up to 25,000 rupees. If some PIO is persistent violator, in that case, instead of financial penalty, that disciplinary action could be recommended by the PIO against that, and the competent authority or the concerned authority of that public authority is to take that action on the basis of the suggestion given by or the recommended by the commissioner. There are few agencies which are being kept out of this mandate of this act under section 24. There are listed 18, 19 agencies in the center, and different states are also keeping their agencies out of the ambit of this act. For example, latest political parties, you can see that the bill is pending in parliament, but there is move that political parties are also may be kept out of the purview of this act, and there are other 18 agencies which are already out of the ambit of this act. But again, this act has made very interesting, you can say, clause in between that if there is any allegation of corruption or human rights violation, then even these listed agencies would automatically fall in the ambit of this act. It means the citizens of this country can seek the information relating to these agencies also if there are, you can say, allegations of corruption or human rights violations. And apart from this, information seeker can request the commission for compensation if there is any loss of or there is any harassment caused to that applicant by public authority. There, under section 19(8)(b), compensation could also be awarded by commissioner, and that compensation is paid by the public authority to the information seeker. However, if there is a penalty is always personal liability of the designated PIO. Maybe the designated or the deemed, but it is personal liability and has to be paid from the pocket, and this goes to the government exchequer. But if it is compensation, that goes from the government exchequer or the public authority account to the person affected or the complainant or the appellant or the affected party by the commissioner. There is also one important you can section that many information are exempted. But there is severability clause also, that if some document is, you can say, kept out of the ambit of this act, but if after PIO going through that act, you can say, find out that there are few pages, few, you can say, paragraphs, which can be severed, which could be, you can say, which are not that, you can say, confidential, those information can be provided to the information seeker. This could be shown that penalty amount, okay. But penalty, again, if it is imposed on the PIO, is mainly for mala fide intentions and for giving or knowingly giving some incorrect information or destroying information. Even if I am designated PIO and I am providing information somewhat late, but I am in constant touch with the applicant, in that case, penalty cannot be imposed upon the designated PIO in that case, but information has to be provided free of cost after 30 days time. PIO or the public authorities cannot take any fund or money for those informations. However, there is protection of PIO in good faith. One has, while providing information, PIO should act very judiciously. One should thoroughly, you can say, go through the application and should then decide which information is to be provided, which not to be provided. Many times what's happening, boss being the first appellate authority, PIO rushes to first appellate authority, sir, whether I should disclose this or not. This practice shouldn't be followed. First appellate authority has different role. If PIO has disclosed or PIO has denied, then people should reach the first appellate authority against that decision of PIO. On the contrary, just when the application, you can say, comes to that PIO, PIO rushes to that first appellate authority whether I should disclose or not to disclose. PIO is many times guided by first appellate authorities, but in such cases, if there is any contravention of the Act, then automatically PIO has to be penalized, not the first appellate authority. Then in such cases, PIO should avoid all this, you can say. They should themselves decide what to be disclosed and what not to be disclosed. Moreover, the beauty of this Act is, this Act has been overridden every earlier Act. I was initially mentioning about Official Secret Act of 1923. Though this Act has not been repealed yet, our second administrative reform, Virappa Moileji, recommended that this Act may be repealed, because after this Act there is not much relevance of that Act. But even now that Act has not been repealed. But anyway, if there is any, you can say, some controversial dispute whether information is to be disclosed or not to be disclosed, ultimately RTI Act prevails or all the acts or the rules of the government, maybe the Official Secret Act or the other rules in the departments. Then there is bar on the jurisdiction of courts. Courts are not supposed to, courts cannot intervene, or courts cannot question the decisions of this as per section 23 of this Act. But even then there are so many court cases in, you can say, Supreme and High Court. It means under this Act there is no provision of approaching courts. But we cannot go to trial courts and session courts. But since Indian citizens under 19(1)(a), which I mentioned in the beginning itself, are enjoying freedom of speech and expression, in that case, if there is such violation, one could approach to High and Supreme Court under Article 32 and 2 to 6 of Supreme Court, 2 to 6 of Constitution. Supreme Court can attend all these appeals under Article 32 and High Court under 2 to 6. That's why so many cases are pending in High and Supreme Court these days. In the last few years, Supreme Court and High Courts are also pronouncing so many nice judgments. Otherwise, there are, you can see, so many, you can see, different judgments from different corners of the country by different commissioners, that many times issues are getting confused, and even people are unclear whether this information is to be disclosed. Some commissioner, you can say, has given some different judgment. And it's nice that in the last 1 or 2 years in particular, Delhi High Court and Supreme Court, Honorable Supreme Court and Delhi High Court, both are, you can say, given trend-setter judgment, which are, you can say, guiding principle for these commissioners and even information seeker in particular. I have mentioned earlier that yes, these agencies are not following in the bit of this Act. There is also that provision that CICs or the State Information Commissions are supposed to prepare annual report of the State Information Commission of the states are to prepare, and CIC for the central, that how many applications have been received, how many have been disposed of, how much money has been collected, and how much, you can say, penalty has been imposed. All these cases are to be kept in record, so that annually these commissions could put their report before Parliament or the state commissions before the state assemblies, as the case may be. This is not happening effectively, but even then these, you can say, annual reports are to be compiled by these commissions. In central government, there is a RTI, you can say, application fee of 10 rupees. If somebody is seeking information under RTI Act, that applicant should attach a fee of 10 rupees. And if it is, you can see, information is provided in A3, A4 size, then there are, you can say, provision of 2 rupees. If the paper size is bigger than A3, A4 size, then public authorities can charge actual cost of that. And for floppy and CD, it is 50 rupees at central level. But if somebody is keen to go through, then you can say record of the public authority, initially itself, while addressing that application to the public authority, if somebody says that yes, I am keen to go through so and so record, then in that case, there is, you can say, no fee for the first hour of inspection. Then for every 1 hour, there is provision of 5 rupee for going through the record. But many times again, public authorities are also complaining, and sometimes citizens also, that oh, there is, you can say, confusion, and public authorities are not allowing us to properly go through the record. All the applicants, I'll advise that should specifically and particularly write down in application that which record they are keen to go through, which information they are, you can say, seeking. Many times while sending that additional fee, applicant are also asking additional information. That cannot be allowed. Means if somebody has asked certain information initially in the application itself, that the same information is provided by the PIO, and if somebody is interested in asking different information, if the public authority believes in transparency and nice enough, it's very good that they should disclose everything. But as per the mandate of this Act, for different information, at the later stage, a different application may be addressed to the public authority. Apart from this, information for BPL is free. BPL applicants are not supposed to attach all such fee as given in the slide. 10 rupees application fee, 2 rupees for A3, A4 size, no floppy and CD charges. There are some, you can say, instances where this has been you can say, used by some people who are above poverty line, but even then using BPL cards. For that, it's okay that PIO should properly scrutinize the application, and then should make out that one is a genuine BPL candidate, or just, you can say, somebody is trying to just misuse the card. One should properly check it, no problem. But even then, it's free for BPL families. At the same time, there are, you can say, under 6th, there is one more important provision that one should typically, clearly add this information is requested, this information, in particular under 6.1b, section 6.1b, that exact information should be requested. Many times it has been observed that applicant has, I need the information of the last 20 years. No, you should write down which date, which year, specify. One should typically specify, though there is no time limit for disclosure of information. People are getting confused that there is a mention of 20 years in RTI Act. If the public authorities are allowing the preservation of record even for 100 years, then applicant could seek the information of the last 100 years also. If the information is to be preserved just for 6 months, then that information cannot be provided after 6 months. There is provision all this. One should comply all that. Otherwise, RTI Act is very clear that there is no time limit how long a public authority should preserve or keep its record in that safe custody. It is the mandate of public authority, and then it may be disclosed accordingly. Okay. Thank you.
As you discussed all the important provisions and how one can utilize this RTI Act, but one thing now the criticism has started that it's taking so much time, and most of the organizations are busy in just replying the RTI. So what is the practical experience, what you have observed over the years?
Actually, the main problem is that public authorities are not fulfilling their own obligations under Section 4. As I told, that public authorities should keep their record in catalogued and index form just like library. Public authorities under Section 4.1b should show more to disclose all the information, but they are not doing it. They are not updating it. They are not, you can say, upkeeping their record. That's why if somebody is coming with some RT application, then those PIOs are rushing from pillar to post. And they then say that we are under so much, you can say, application, so much work, but they are not fulfilling their own obligations. Then it's nice that CIC or State Information Commission from time to time should issue some necessary instructions that all these should be updated.
So
but many
it means a kind of mismanagement on the part of officials that's leading such kind of criticism. The second thing which I'd like to know that we have ministries, we have departments, we have autonomous institutions. So such kind of a structure in India we have. So suppose one want to seek information on the departments. So he should directly contact to the department, or he can go to ministry also. What are the exact location of the seeking information, especially in these cases where the diversity of multiplicity of the department works?
Actually, information, of course, we can seek even of private bodies,
Okay.
autonomous bodies, and of course pure government departments. If it is pure government departments or even autonomous, there are PIOs and APIOs designated, and everybody should know. And
In all
even-
organizations?
Yes.
Okay.
But if it is some pure private body, in that case, one shouldn't directly approach the pure private body. Instead, though courts have been issuing directions to these private universities in particular that they should have designated PIUs and they are also falling in the ambit of course they are falling. But if it is pure, you can say some small organization, in that case, information should be sought from the controlling public authority instead of approaching those private small organizations directly.
Okay.
In case of private authorities, one should directly approach the controlling departments, and if it is autonomous but getting government funds, or it is pure government departments, then one should directly approach, and there should be PIO in all these public authorities.
Okay, one thing you mentioned that if something is going in the court, one can seek information, but it's on jurisdiction, or we can say on discretion of the PIO whether he fits the reply be given or not, yeah, what information to be given or not. So what is the discretion he can apply, and wow,
There is a section 21, good faith.
good faith. Okay. The complete arbitrary
And-
subjective.
No, yes, it is expected of a PIO that one has to act very judiciously, one should be thorough in act. Even PIOs are not thorough, nor they are going through the act. Piecemeal arrangements are made. What I was, you can say, trying to explain is that while dealing with some RTI application, they should systematically go through the, you can say that application and even through the act, and then they should decide. If it is not done, then it's not right. Otherwise, if somebody was, you can say, nice enough to interpret it correctly, then one is having that good faith protection also.
Okay. You also,
Arbitrarily, commissioners also cannot impose penalties.
okay. And on the part of CIC, as you said, they are compiling the number of PIL, number of the things, what is happening, all this. So sometimes some offices or some department are not able to send what has gone over the last 5 months or 6 months. So in that case, is there any kind of penalty or some kind of disciplinary actions in the hand of CIC or not?
No, actually, this you can say some problem area, you can say.
Okay.
Commissioners have this power to impose penalty on PIOs alone.
Only PIOs.
PIO may be designated or the deemed one.
Okay.
It means virtually everybody in the office who is custodian of the record or who is disseminating information. But they have no power to, you can say, penalize first appellate authority or the public authority in common. But there is some, you can say, weapon in the hands of commissioner that under 19(8)(b, they can award compensation very frequently. I may approach commission, sir, I couldn't get this information, I was harassed to that level. Then commissioners are enjoying that power of compensation. And that compensation amount is paid from the exchequer of the public authority, virtually penalizing public authority. And if some public authority is just bearing that cost, it means that public authority is not carrying out, you can say, that provision of that act effectively or working effectively. That question mark on the working of that public authority is raised. That's enough.
So what are other grey areas?
What are the great?
Grey area, weaknesses of this article?
Awareness even after more than 8 years is not, you can say. Awareness is lacking. Departments are not making sincere efforts in making the people aware of the services they are providing or the information, you can say, system developed there in the department. Some, you can say, these applicants are also, some are just acting as a conduit. Somebody is asking so many information, though that may not be relevant. But what's the main, that even if I am asking, you can, information, I should try to use it. Just for sake of seeking information, and you can say just having those pages around without using them, and then you can say harassing them. It's better that we should collect information and then should try to use those information for introducing good governance. BPL card misuse is also sometimes common. And again, the commissioners many times, information commissioners, are political appointees, having affiliation with political parties. Quality and of, you can say, these appointments also are many times questions.
So many of the what we find that retired IS officer or other people are holding such kind of posts. So because they have served in the system, so expected from you that they will do the things in a better way. So what other mechanism you suggest that need to be put into the place?
And actually, yes, this is happening. If the party, you can say ruling party is appointing somebody retired officer, that retired officer many times is there to protect the interest of the ruling, you can say, party. Normally, they are nice in disclosing so many information at, you can say, some small offices and officers. But when it comes to, you can say, some serious affair, many times they are not, you can say, giving nice judgments also. But there should be, and government is very selective. There is no proper, you can say, that board or some, you can say, selection procedure is not followed. If some vacancy is there, that is not properly, you can say, advertised, or you can say applications are rarely, you can say, sought by the government. It's better that as and when there is some vacancy, there should be proper advertisement that we are seeking information, we are seeking application for that post, and then that should be properly selected or appointed. Otherwise, CMs and the secretary, they are appointing many times. That opposition leader is not taking into confidence. But yes, whims and fancies of the ruling party, you can see there.
So we can say these are the teething problems which can be sorted out with passage of the time.
Yes.
Okay. One more thing I'd like to know from you, that legality of this, because some of the information we get from the RTI and people are putting as evidence in the court, to what extent it is?
There is no harm. There is no harm. If some information is, you can say, disclosable under RTI, then let it be used anywhere. The main purpose of this is, of course, if some information is to be disclosed, maybe for the good governance or for the cases, how does it matter? If it is disclosable, it could be used anywhere.
Okay.
It doesn't mean that I cannot use it in the court or somewhere else. I may use it anywhere. That's nice. If some information is not to be disclosed, naturally that you can use the proper section, and then PIO should quote that proper section that due to this reason this cannot be disclosed. But if PIO, after properly screening the act and the provisions, has disclosed certain information, I have every right to use anyway.
And that has a valid evidence?
No, of course. If naturally public authority is saying this is our disclosed information.
And in case of conflict, suppose the answer provided through RTI varies from the same answer provided in the court, what will prevail?
And, actually, then it's the, you can say, up to the courts to order inquiry, or if it is required. But if it means public authority is giving different information in courts and different to the information seeker, certainly some that is incorrect or this is incorrect. Any information disclosed under RTI can be used anywhere, and it means they are trying to play safe. They are having different records for courts and that. But even then in big public authorities, it's happening. Okay. If there is one headquarter, there are so many, you can say, district and divisional headquarters, information may vary. But yes, information supplied under RTI can be used and could be different from provided in the courts. In that case, yes, courts should pull up those public authorities for effective, and that it should be effectively implemented. And courts many times in recent past has been very tough. Very tough.
Okay. So what are your suggestions to make it more effective, more for the welfare of the public, we can say, at larger section of the public?
Honestly speaking, this is the toughest act in world as far as transparency, you can say, right is concerned. Like our constitution and other acts, it needs to be just more effectively implemented. It is more effectively followed by the government, by the commissioners, by the public authorities. Many, you can say, countries are not having this, or many countries are not even having written constitution, they are running effectively. If this act is nice, I don't see any problem in the act. And but there are, you can say, some implementation problems. their public authorities and the government needs to be more serious. Otherwise, I don't see it.
Do we have questions from viewers?
No, I just found it a very enlightening lecture because I got to know so many things that I didn't know earlier. But yes, I'm very happy to be here. But no questions asked.
Okay, fine.
Thank you.
So, as we discussed this all, but one more thing that needs to be discussed is that transparency is one part of the, we say, governance or the, good governance, because for the good governance we need more transparency. But the governance is also other part of, when we see it, one is the transparency, the other is the governance. When this transparency hamper the governance, so what approach one need to adopt from the administrative point of view?
It's there in the preamble of this act,
Okay.
and even in section 7(9). And I also, you can say, in the very beginning, I told that a balance has to be maintained. Means one just cannot, people just cannot be there in the offices with all the time applications, and PIO or the department is not there always to provide information. And balance has to be maintained.
Okay.
There is a provision in the preamble itself that efficient operations of the government are to be maintained.
Okay.
If efficiency is totally compromised, then even PIO may deny certain information. Yeah, I can say that this information requested in this format cannot be supplied. Or if this is, if the information, sometimes people are asking information of last so many years,
Yes,
may not be that relevant. It means naturally that would be affecting the efficiency of the department.
So many years other parties or suggestions, why not decision taken on this? So such kind of information need to be given, or officers need to withhold these things.
Yes, PIO first of all, if the information is very bulky,
Okay.
then may sometimes use preamble of the act. Okay, balance has to be maintained. I cannot provide this bulk information. One may invite that applicant to the office itself, that you scrutinize and collect the required information. Under section 21, he has done his duty in good faith. And many times, of course, PIO, that may be very nice to them, but all the information cannot be supplied sometimes.
Okay. So, well friends, with this word we like to conclude the lecture. I thank all of you for watching the lecture, and on your behalf, I thank Dr. Rajveer Singh Dhaka for giving such an insightful lecture on this very topic. Thank you very much.
Thank you very much.